Good afternoon, everyone. This is Beth Wadham from the Association for Contemplative Mind in Higher Education, and welcome to our May webinar, which is Integrating Trial Advocacy and Mindfulness Theory and Practice. And we're with David Zlotnick, Professor of Law at Roger Williams University School of Law. David is a graduate of Harvard Law and began his distinguished service at Roger Williams University School of Law in 1996. He teaches law, criminal procedure, and trial advocacy, and in 2002 he was selected as a Soros Senior Justice Fellow by the Open Society Institute. In 2008 he was awarded a Contemplative Practice Fellowship by the Center for Contemplative Mind, and that's when he developed his Mindfulness and Trial Advocacy course. His own practice includes Vipassana meditation and yoga, running and biking, and meditation retreats. He's completed an 8-week mindfulness-based stress relief program at Brown University and is also a graduate of the Prison Dharma Project's Path of Freedom training. He now leads meditation sessions for inmates in Rhode Island, making use, I believe, of a similar webinar delivery system. So thank you so much, David, for offering this webinar to our network, and now I'll hand over the presentation to you.
Great. Thank you, Beth, for that lovely introduction, and welcome to everyone. Because you're all here, I'm not going to spend that much time trying to sell you on the benefits of mindfulness to yourself or to education, but rather we use our time to sort of walk through this experimental course that I taught 2 years ago, and I'll again be teaching this coming spring. And I'd like to see, for those of you who are educators, if there are ways perhaps that you can think to generalize what I've done and apply it to your work, and for those of you who are attorneys, to see if there are things in the course that perhaps you can bring into your practice in some way. And I encourage you to be thinking about that and, in fact, typing questions as we go so that perhaps we can have some time for a discussion at the end. Still, though, I have to talk a little bit about law and law school to give you a little bit of context. So first, I want to talk just a little bit about the challenges of integrating mindfulness into law and integrating mindfulness into teaching trial advocacy. I think we all know that the image of trial lawyers in our culture, which is in fact often true, is that they are, trained to be confrontational. They're often stressed out, and to put it nicely, they often are better at negative communication skills than positive ones. And of course, trials are set up as a zero-sum situation. It's competitive, right? And there's a winner or a loser, and the question obviously is, where is the compassion or standing in someone else's shoes in all of that? And then finally, in thinking about law school, clearly law school is large part socialization. We're trying to turn college students or people who've been in the workplace into lawyers. And traditionally, that sounds like we ask them to put aside their values and beliefs. We ask them to become competitive. We ask them to become more analytic. But that being said, I think there are also some overlooked opportunities and overlooked bridges to mindfulness practice. And that is, it is clearly a service profession. And many people are drawn to law, at least initially, because they want to help clients, they want to help society, they want to help victims. And so part of mindfulness and trial lawyering is to reawaken that calling. Secondly, trials, although they are a conflict and a winner or loser situation, it is certainly one of the ways in our society that we try to responsibly and democratically apportion responsibility for conflicts. And juries are really democracy in action, and there's really a very positive component, at least there was for me as a trial lawyer, in working with people to try to figure out what happened and what's the right result. And certainly law school has changed. There's a much heavier focus now on experiential learning, on skills and clinics that try to engage students as complete human beings. And students see this difference, and they eagerly enroll in these courses. They want something different than the traditional or even modified traditional Socratic classroom. Now, that being said, there are still some challenges to students in integrating mindfulness into the classroom. Many of the students that took this class with me the first time had no exposure really to mindfulness. They just wanted to learn trial advocacy, but they were scared, and they thought this would be the kindler, gentler version. Many who have had some exposure have done it through yoga or through other physical practices. And this was an afternoon course. The students often came a bit stressed out. They were tired. They have lots of competing demands. And so simple sitting meditations, the most basic Vipassana practices, are a real challenge for them. They either get sleepy or they space out. My teacher at Brown University, a wonderful researcher who's doing some great stuff on neuroscience and meditation, said that for many people, practicing meditation is really just practicing spacing out. And for law students, they're so out of their bodies and so into their heads that even just sort of simple counting, breath, following breath, they're either losing it or finding it impossible or measuring themselves and feeling they've failed. So the first thing I want to do, and I want us to do a very short practice before I get into the substance here, is to think a little bit about concentration practices and how I had to learn with them to make the concentration practices very concrete. Fleet Mall, who's the head of the Prison Dharma Project, uses the concept of close placement. That is, trying to have the object of meditation be something that is very physical rather than mental. Okay, so I wanted to first, just for those of you who like I want to have you to have the experience my students had. So we'll just do an abbreviated version. Normally we would do a 5 or 10 minute sitting to start class, but I want you, if you would with me, to just, if you're not already comfortably seated, to put your feet, in a comfortable position, to have as upright a posture as you can. And just for a few moments, I'd like you to concentrate on your breath. But what I'd like you to do specifically is, as you start to breathe, if your mouth is closed, then I'd like you to pay attention to the temperature of your in-breath and notice its coolness. And on your out-breath, again through your nose, notice the slight increase in temperature. And you can do the same with your breath if you're breathing through your mouth. And if you don't notice the temperature difference, that's okay, but see if you can, rather than think about breathing in and breathing out, notice the physical sensation through the medium of temperature. And so if we can all do that, if we haven't already started, breathing in and breathing out with close placement on the temperature of the breath, just for a minute. Okay, and that was just a taste, and I'd love, obviously, some feedback as we go along. If you haven't tried that practice before, whether you were even just in that 1 minute able to notice anything about your ability to stay with the breath in a way that might be different than when you simply do some counting or a verbal breathing in and breathing out in your head. The other practice, sort of close placement, is from a teacher called Shinzen Young, who I recently met through Brown, and he does some interesting things with visualization within the brain. And again, I'm trying to reconnect my students to their bodies and get them out of their heads. And so this practice involves closing your eyes. So everyone close your eyes and look at the space just behind your eyelids, if you can, inside your mind. And some people see something dark. Some people see some light, depending on the lighting in the room. And in your mind, try to focus on that space and the visual sense. And for many people, not all, but for many people, pictures will arise. Sometimes patterns, sometimes images. And just see them. And as those pictures arise, you say to yourself, seeing or seeing. And then if you can stay with that image, at some point it will go away. And you simply note that, and you say something like gone. If you see nothing, that's fine. You just say rest. And if you see some color or some shifting pattern, but no specific image, Shinzen-Young's noting is see flow, or just flow. And like with all concentration or noting practices, if you get caught up in a story about the image, or in fact if you completely disappear into some other thought, simply with kindness and no judgment, come back to that space behind your eyes and start again. And so once again, let's try that just for a moment or two if it's a new practice for you, and see what happens when you close your eyes and just focus on the interior visual monologue that we have, which in some ways is very similar to the mental monologue with which I think many of us are more familiar in meditation practice. So here we go again. And again, use whatever noting practice feels good for you. Seeing, gone, rest, flow. Our mind creates pictures. There's always a movie going on once you close your eyes. Okay. And again, just a taste of that practice. And now if we've gotten a little more centered, I'll move on and probably talk a little faster so I can get through the slides and we can get to watch a little video clip from the class. There we go. So just a little on the basics of trial advocacy teaching. It's a simulation course. That means the students perform small segments or longer segments of trials in a courtroom setting, usually in an actual courtroom in a law school. It's a very interactive class. The students are moving around constantly from the witness table, from the witness stand to counsel table to the jury box. There's a lot of active learning going on. The National Institute of Trial Advocacy actually has teacher training and gives professors a critique methodology that allows them just to concentrate or focus for each student on one or 2 points, and so that the class benefits from the critiques of all students, because the professors trying to keep the critiques limited, really to keep the students moving and to have as many students perform as possible. I actually teach the students that critique methodology, how it works, how to do it for themselves and others, and so they become both active learners and active teachers as the course goes on. The course goals, obviously it's trial advocacy, there's skills training, we call that the law and order part of the class, where they're actually learning how to do direct and cross-examination. But there's also an analytic component or a theory of the case. Students have to learn how to take whatever crime or tort is the subject and figure out how to meet the elements of whatever the cause of action is and figure out which facts in the witness statements matter. And so they have a coherent and powerful theory of the case. It's also a class in the rules of evidence in action. They've had evidence, but they have to learn how to object. They have to learn how to recognize when what the other side is doing is inappropriate and how to respond to objections to their work. Finally, it's a lawyering on your feet kind of class. It's a combination of preparation, adaptability, and repetition. If they're going to object, they got to stand up. They've got to say object. You only learn how to do that if you do it a lot. So I set out the course structure just so you could see what it was. Each class, for the most part, there was a weekly trial advocacy assignment in which it was either a direct across some specific technique. But we began with a centering practice, much like we did here. Sometimes I led them, sometimes I had a guest from the community, sometimes I had a student prepare it. Then I tried to match the mindfulness practice to the trial advocacy lesson plan, and I'll talk about that in a little bit more detail later on in the presentation. I also tried to sometimes integrate the mindfulness practices into the simulation, and I'll describe one of those. We also had reflection papers for particular assignments and journaling throughout the course. And I did have the students work together both in preparing the assignments, and also we did partnering mindfulness exercises and group exercises as well. And of course there were some brief lectures. I had 3 basic goals for the mindfulness part of the class. The first was just to give them some better coping skills to deal with the stress and anxiety of trial work and public speaking. And I think those practices can be extended really to any class that involves public speaking. Second, as I just said, there were some efforts to sort of match the mindfulness practices to the trial advocacy lesson for the day, and that was the most fun for me. I'll just give you sort of a lead-in that, Pema Chodron says the hardest and the most important time to practice is when things fall apart, and that's exactly what happens in trial all the time, and nothing succeeds as planned, and the key is to keep going and to recognize and roll with the punches. So that was a huge part of the class, was learning how to deal with things falling apart. But third, I wanted to expose them through reading and through practices to the compassionate wing of Vipassana meditation, and to plant seeds in them that they could become trial lawyers who were kinder and more compassionate to themselves and others, more self-reflective so they could serve their clients better, and learn how to create less conflict and pain in the trial process so that they didn't burn out, and so that the people they came in contact with as witnesses, as jurors, as opponents, did not have to suffer any more than necessary in the context of the course. Okay, so now let's just get a little specific so we can move through some of the material. All trials have some portion of the trial when there is a direct examination. And just briefly, what the lawyer is trying to do is to sort of create a movie script. That is, they have to set the scene, they have to give enough detail so that the audience, that is a jury, understands what's going to happen, like a backdrop. And then, particularly for the most critical action in the trial, the crime, the car accident, the surgery, to create an almost frame-by-frame picture of that critical action, which then gets reinforced with evidence, with documents, with diagrams, with experts. It actually is quite hard to do. And over the course of years of teaching this, I realized that mindfulness practices could help the students do some of these things better. So what do I mean by that? One of the hardest things, and I was a trial lawyer for many years, and I've watched many trials, and jurors complain constantly that the lawyers are not listening to the witnesses' own answers. And if the lawyers aren't listening, why should the jurors? And why is that? Well, from a mindfulness perspective, it's because the lawyer's not in the moment. They're not being present. They're so worrying about their next question. They're so worrying about what's going to happen next. They're not listening to the answers. And you can tell them that over and over again, but they don't want to do it. So what I did to them once, and a lot of the times in this course, I kind of played fun little tricks on them, which they kind of liked, actually. I told them that they were going to have to redo a direct examination from the week before and learn it really well. So they liked that. They didn't have to do anything new. But then they came to class, and I blindfolded them. And I made them do a direct examination from memory, listening only to the voice of the witness and only the memory of the story in their head. And it worked because they really had to listen, and they realized they knew the events or the fact pattern well enough that they could let go of the of the plan and simply be with the witness. And the mock jurors listening felt absolutely the same way, that it became more real and it became a real conversation rather than a very poorly executed script. I also wanted to work with them on compassion practices. Trial lawyers in real life get the most out of their witnesses and their clients when they're really there with them. And some of the stuff that we deal with is quite hard. So I did different things with them. I had them read Snow Falling on Cedars, which is my favorite book that involves a trial. But we also did some partner compassion practices, and I got this one from Jack Cornfield from a retreat I went on. And I just had them sit with another student they didn't know well and just look at the person and imagine every terrible thing that could possibly have happened to them in their life. Just make it up without any knowledge of the person. And then I had them sit for another few minutes and imagine all the wonderful things that had happened or would happen to that person in their life. And then I had them do their direct exams, emphasizing that no matter what limited set of facts were relevant to this particular trial, every witness comes to this event as a full human being with a whole lifetime of successes and failures and happy and sad things, and to truly try to be with the person rather than see them as a tool or an instrument. I need these 4 facts from you, now go away. And again, the students found this a bit challenging, but I think they saw the point, and I think some of it rang true. Cross-examination. Unlike TV, the real goals of cross-examination are actually fairly limited. You really have just a few points you want to make that might undermine the accuracy or the certainty or the relevance of the testimony. Yes, there are lying witnesses, but for those of you who are trial lawyers out there, you know you can't really 100% catch them very often. What I have found is that jurors actually would much rather believe someone is mistaken than lying, because jurors don't really like conflict that much. Secondly, we always talk about witness control, and students think that's a question of, being tough and mean and hard. But actually, jurors don't like mean people very much. So we try to use some mindfulness practices to help the students first relax into cross-examination and see that it's a combination of effort and ease. So we did some balancing poses in yoga, which are challenging. And if you try too hard, you can't do them, or you try to cheat, or you fall over, or you get mad. So, doing tree or doing poses in which you're trying to balance in a suit is even harder. And we got some good laughter out of that. But I also did some things like having the students use the pause. My friend Tara Brock, who teaches in Washington, D.C., talks about the power of the pause. And so many times the students would make a good point and nobody would get it because, again, they were rushing into the next point or the next question. And I actually had them write into their notes, pause, let it sink, let it land. Appreciate this moment when you and the witness got to a place where it was clear that maybe things weren't as clear as they may have seemed initially. And the last one was the tennis ball, which for those of you who ever had family meetings may have used, where you can only talk when you have the ball. And the idea there was to stop making this a confrontational practice and really see that a cross-examination is really a series of questions and answers in which people are trying to learn from each other. How sure is the witness of what they saw? How really were they in the position to see what they claim they saw? And make it a cooperative conversation and not necessarily all confrontational. The students definitely like that one. There were a couple more that were pretty interesting. I want to keep moving so we get to the video, but I did a couple of things on anger and fear, which are really huge parts of what trial lawyers struggle with. I had one class where I had a guest attorney come in, and I put up a good student against him, and every time she tried to do anything, I had the attorney object, and I sustained every single objection. And watch the student become angrier and angrier and angrier. Well, I had taught them an anger meditation, and when I saw the student about ready to explode, I rang a bell. I had the student do the anger meditation, and then I allowed her to come to the bench and argue with me. And we used that practice a few times of in the middle of a difficult moment in trial, you never in real life get the opportunity to take, 60 seconds to recalibrate. But I wanted to at least see that it was possible. And so whenever the student would have a breakdown in a performance, I would sometimes ring the bell and they'd either do an anger or a short fear meditation to allow them to come back into their body, to come back into this notion that they can't control everything. I did the same with what I called exploratory cross-examination, in which we gave them a brand new witness for a trial packet they knew, and we did a meditation on the fear of the unknown before then allowing a student to cross into that terrible territory when you really have no idea what's going to come out next. I'm taking a little pause just to let everyone catch in, and the next slide. Okay. We did some other things. Exhibits are really boring. The students hate them. It's all technical rules, and they all want to be Perry Mason or some law and order attorney. But they have to learn the technique, and they have to do it right. They have to think about it. So I did a tedium exercise that I learned in imitation class, in which essentially take 5 or 10 minutes where you have to draw a repeating geometric pattern and try without too much effort to keep the pattern consistent. And if you notice that the pattern changes or the drawing gets bigger or smaller, that's your moment to come back. And you can either go back to the shape or the geometric pattern you initially planned, or go with the new one. But the idea was to learn how to stay focused while doing something technical. And I have 2 of their drawings for you. And here's the first one. And here comes the second. And you can just see how differently the students dealt with these two the instructions in this manner. Okay. So moving along, and again, I'm happy to answer questions about any of these. I just want to sort of give you the overview and have enough time for questions and discussion. More generally, I wanted to, in the course, have them be more self-reflective about learning. And one of the hardest moments for them in law school and in experiential courses is they're going to get a critique. They're going to do something they worked on very hard for a few days, and there are going to be parts that didn't go well. And certainly, part of the needed methodology is to note when things go right. But students and trial lawyers in particular learn more from their mistakes than from the things that went well. And students struggle a bit with this critique moment. So I gave them a Pema Chodron reading on embarrassment. Many of you might be familiar with her gorilla story. You look in the mirror. No matter where you look, you see a gorilla. It's just not pretty. And I wanted them to really start recognizing that, from my perspective, they didn't make mistakes. There's no point in my being there. But more importantly, that learning how to learn from your mistakes while sitting with your embarrassment is critical. So I even brought a gorilla mask in and invited them all to wear it while they were being critiqued. And of course, the only thing that happened in that class was I ended up wearing the gorilla mask. But I think the point was made, and I think more importantly, in any experiential learning where critique takes place, using mindfulness, using some kind of discussion about how to sit with, we won't do it perfectly the first time, and that there is so much to be gained from making mistakes, really adds to the learning, and it adds so much to the quality, the emotional quality of the course. I also did an eating meditation with them. I wish this were true now, but whenever I had a trial when I was younger, I'd lose 5 pounds because I wouldn't eat. So I've done eating meditations before. Never really loved them that much. I have a new one I like even more. It's better for trial lawyers. You give them a craisin and a golden raisin and make them pick one and figure out why they picked one. But I did an eating meditation with them where I told them they didn't have to prepare for class. They'd be a guest, and I'd give them lunch. They came to class, they got a raisin, and they were, annoyed. Then I told them actually they were doing a full trial that day in a group, and I gave them lunch. And I asked them to learn in the half hour they had to prepare the trial as a group to eat their lunch mindfully. So first we did the raisin, which was, planned meditation, and then they did the impromptu eating a real lunch. And they really did talk to me quite a bit about how law school has taught them to choke down their food and not really enjoy it. And I think they got quite a bit out of that one too. And then finally, in terms of just overviews, we did a bit on value conflict. Sometimes trial lawyers have to do things that are really hard. And the paradigmatic example is cross-examining a rape victim in a consent case, something I never had to do because I was mostly a prosecutor and defense cases I've done. So I had some lawyers come in with to do that, and we talked quite a bit about how do you maintain your value system when you may in fact be doing something harmful. We talked a little bit about Prince Arunja, I think that's how you say his name, who was sent to battle against his family and friends. And we talked just a little bit about both the limits of mindfulness, but also about compassionate self-examination when you find yourself being asked to do something as a lawyer that doesn't feel right. And you may make a career change, or you may find a way to honestly reconcile the pain of the moment with your role in the legal system. Okay, so I've saved opening statements for last because this is what the video clip will deal with. The goal of an opening statement is to tell a persuasive story that explains your theory of the case but without arguing. And I use the analogy of Goldilocks and the Three Bears. You can't give them too much. You can't give them too little. If you overwhelm them with facts in opening, it's too much for the jury. If you underwhelm them, then you risk them not really understanding what the key facts, the key witnesses, or what your theory is. From the mindfulness perspective, there are really two pieces. The first was so many of them come with some public speaking anxiety. And so I have a good friend, Michelle Hubbard, who's both a yoga teacher and a trained actress. And for years she's been coming to my class and doing some posture exercises with them, some standing yoga, and some breathing exercises to help them find their feet and find their breath. And I have those available. Certainly, some of them are on the web, and I certainly can make them available later. But the second piece, which is what I want to show the clip, and which is a bit more interesting and more controversial, is I find that the students over the years, they tend to put on a trial lawyer persona, even in the very first class, something from a TV or a movie. Sometimes it's someone very aggressive, sometimes it's something stiff, but because it's a persona, it's not them, and it doesn't fit well, and the jury knows it, and the students know it. And for the most self-critical students who can't live up to this ideal, they often just panic or freeze or go through the motions. If the students who over-identify with their persona often come across as insincere, arrogant, abrasive. Even the ones that find one that fit, that is a palatable person, they proceed competently, but it comes at the cost of leaving out what is sort of compelling and interesting and compassionate about each person. So what we do in this class, and this is with my yoga teacher friend, we have them do a performance to try to help them discover their authentic voice. We have them do a performance, and then we make them do it again in different little pieces of it and try to get them to be vulnerable and be who they are. And they're not used to it, and they don't like it, and they do it. They find it incredibly liberating and often very effective. So what you're going to see now is a clip of opening statements based on children's stories. I use like The Cat in the Hat Comes Back, which is intentional infliction of emotional distress. I use Horton Hatches an Egg, which is a child custody case, The Three Little Pigs. And this particular student I chose because she's an excellent student with a very well-developed trial persona that she was not really interested in letting go. And so this is a class in which maybe what I did and my friend Michelle didn't work that well, but I actually think it's a better place to start a discussion than showing you something where it went great. So let's go ahead and see if we can go ahead and watch the clip using the link in the chat box. And I'll come back in about 14 minutes for a discussion.
Great.
Okay?
Great. Thank you so much, David. So
And,
now is the time to go to your chat box and click on the YouTube link to open up a new browser window in YouTube, and we'll all watch that together. After it's over, close the browser window and return to the webinar. Great. Hey,
Okay, we're
David.
back.
Yeah, we're
I,
back. That was that was really amazing. I must say, for a person who's not hasn't seen, the work that goes on behind the scenes there with educating lawyers, there's a lot of craft to it, and wonderful, wonderful experience. And you're,
thanks.
yeah,
Uh,
provoking them. Wonderfully
it's my
effective.
favorite class to teach.
Yeah.
Thanks. So I thought we've got 8-9 minutes for questions, comments. I'd love, obviously I'd love feedback on any of the mindfulness stuff that's in here, any comments on the video. We really wanted to make sure we save time for participants to
Yeah.
comment or question.
Yeah, this is the time you can type something in, and David will address as many of them as possible in the next 7 to 10 minutes. So it was great to all be together and share some practice time together too, David, with the breathing exercise and the kind of visual experience. I really found that helped to pay attention to kind of physical things rather than mental, such as counting or something,
Right.
and quieted that down a little bit more than
Right.
usual. Thank you.
Thanks. So I see a question: do the students continue their mindfulness practices after the course concludes? Some of them graduated already. I've heard from some of them. Some of them have continued to practice. Some of them were, well, this was really fun. I see it often as a planting of a seed thing, and I think I'd like to talk to them in 5 years or 10 years at the reunion and see if it made a difference. The next question actually goes right to that. Did I use mindfulness practices when I was in AUSA? Did I come to that later? My answer is I took yoga my very first semester of law school and didn't stay with it and did not come back to yoga and meditation until I had already started teaching law school, and I wish I had. I think it would have made a big difference in terms of my longevity, and I think as much as I tried to be a compassionate trial lawyer, I think it probably would have helped me do better. Next question: what resources do you recommend for learning about mindfulness practices? I'm not a shill for the Center for Contemplative Mind Society. I am just a huge fan. I think their retreats for lawyers are absolutely wonderful. I think that's a great place to start. I think the mindfulness-based stress class, relief class that I took that's based on John Kabat-Zinn's work is a great thing for lawyers to do because there really are so many practices I found relevant to the kinds of stress that trial lawyers experience. Okay. Next question is, oh, hi, Rhonda. Does your class touch on alternatives to traditional trials, such as incorporating restorative justice models? I gave them some reading on that because we didn't actually do anything on the first time through because thanks to the funding I got from the center, I was able to bring in a lot of outside speakers to do some really intensive mindfulness with them, and then I wanted to just touch the basics, but maybe in the spring of this coming year I'll have time to do more. The next lawyers retreat is September 8th to 11th at Spirit Rock, thanks to Doug Chermak.
Oh, great. Yeah, we were going to
center.
mention that too, so that's terrific.
Yeah.
We can also post resources when we post the webinar. You had mentioned some things about, yogic activity resources or, any other attending material we can post up there with the webinar for people to check in later.
Right. So here's a question from Sam Pryor. What do you recommend to students to do at trial to get mindful quickly when things go awry? So that was a big part of the course. I think mindfulness practices really only work if you're practicing before things go wrong. And so one of the teachers I had did this thing where we're meditating and then without any warning claps her hands really loudly just to jolt us. And then we practice, incorporating that into mindfulness. So I think just pure sitting practice with eyes closed may help people calm down and de-stress, but I think practices to help people dealing with things going awry have to be a little more challenging. So practicing where there's loud noises or children around, or practicing going to trial and practicing while sitting and watching and sort of being in the person's shoes. I used to go to trials and, oh my God, what would I do if this thing happened? Well, now I would go, and what would I do to stay calm if this thing happened? I do that when I coach trial team. I go and I'm just out of my mind wanting to get up there and do it myself, and now I do mindfulness practices when I'm watching others in trial having a hard time. So that's something I would recommend. But the key really is to have a practice that you feel comfortable with, whether it's a simple breathing practice or a compassion practice when someone makes you really angry, to recognize and to learn and send them Tonglen, to send them compassion for the judge who's yelling at you, that you can do in just 60 seconds. To have that ready to go so that you don't become reactive in trial, because that doesn't ever help you with the judge or the jury or the witness.
Thank you, David. There really has to be a foundation there, yeah.
Yeah.
And I think we're going to have to wrap it up. I'm sorry the time got a little short, but I want to really thank you. It's great to see just how successful these kind of innovations can be when an experienced teacher with a well-organized course brings them forward. There's no amount of contemplative practice that can substitute for that. And this looked like a really well-designed course. I imagine that everybody has benefited from it who's taken it, and I hope that you've stayed in touch with some of them. You mentioned that the girl in the video you had been recently in touch with. So.
Yeah, I just heard from her this week.
That's great. So great. So thank you all so much for joining us today. And if there are a few other questions that we weren't able to address, we can also, if you're willing, David, to post answers to those if we think it would be helpful. And
sure.
Yeah, great. And then I just want to point us in the direction of our next webinar before we sign off. We'll be gathering again here online September 28th. We have Jeremy Hunter, who's professor at the Peter F. Drucker Graduate School of Management at Claremont Graduate School, and he's going to present Developing the Executive Mind, Teaching Managers to Manage Themselves. And that's based on a course he teaches to a diverse group of students, including sheriffs, neuroscientists, and small business owners. So that also should be enlightening. And registration will be available on the website later this summer, and we'll also send out the email announcements. So I hope all of you might be able to join. And for now, farewell until we meet again.
Great. Thank you all very much for coming.
Thanks.